Hi, this is Catherine Klasny. It's noon and we're going to begin recording. Good afternoon, everyone. Please note that attendees are muted. If you have a question, you can enter it into the question dropdown of your GoToWebinar control panel. Our presenters will address it either during the program or afterward. If you don't want to see the control panel, just click the orange or red arrow to minimize. Also, please note our co-sponsor, the University of Florida Levin College of Law Institute for Dispute Resolution. And here are our presenters. Howard R. Marsee. Hi, Howard. He was a board-certified civil trial lawyer for 20 years until 2003. Since 1996, he served thousands of hours as a mediator, arbitrator, and special master. He's certified by the Florida Supreme Court to receive circuit civil mediation appointments and by the U.S. District Court for the Middle District of Florida to receive mediation appointments in cases pending before that court. He's also approved by the Florida 5th District Court of Appeal as an appellate mediator. He is a former member of the Florida Bar Standing Committee on Professionalism. And there's Cristina Maldonado. You can see a picture of her and in video too. Hi, Cristina. Her law dispute resolution practice spans 10 years, and she is Florida Supreme Court certified as a mediator and qualified as an arbitrator. She's fluent in Spanish and Portuguese. Cristina is one of a handful of primary trainers in Florida and has helped train and mentor more than 100 new mediators. Before becoming a lawyer, she spent 7 years administering a $22 million budget, a 15-person team of employees and contractors, 2 international field offices, and field operations across 9 countries for a government contractor. Both Howard and Cristina are members of the National Academy of Distinguished Neutrals. And now I'm going to turn it over to Howard.
All right. Good morning, ladies and gentlemen. I know all of you have been living in Zoom land for a while. So today, Cristina and I are going to welcome you to webinar world. We've all been sitting around in our pajamas and our house coats for a long time, just thinking. Well, today we're going to have some fun. We're going to be thinking about thinking. And I warn you in advance that thinking is not exactly what we think it is. You've all seen Rodin's The Famous Statue, The Thinker. And I'm sure all of us in our mind's eye visualize a man deep in thought, analyzing every possibility and every permutation. But if Rodin had known what we know today about cognitive biases, he might have redone the statue. We are not, strictly speaking, rational decision makers. We like to think we are. There's, I think, John Locke's famous saying, I think, therefore I am. But we do not necessarily make decisions on logical or economic bases. And for those of us who negotiate or mediate, we see this every day. Our decision-making process is burdened by what we call cognitive biases, or maybe even a better term is cognitive illusions. And in short, our information system has limitations, and those limitations often lead us to make poor decisions. As negotiators, probably our most important job is to understand how cognitive biases may be interfering with our own decisions and how it may be interfering at any given moment with the decisions that the other negotiators make. As mediators, Cristina and I observe negotiators at work every day. Some are great, some are good, some are okay, some are downright poor. But Cristina and I are in a unique position to see what makes the great negotiators great, and the poor ones poor. We have become students of negotiation and the way people make decisions. I know I myself read everything I can get on negotiation and on the way we think. And some of the ways we think may well surprise you today. So, our goal today is to identify a few of the more prominent cognitive biases and their effect on the negotiation process. And maybe we can offer a few thoughts with dealing with them. There's one caveat we need to give you here. There are more cognitive biases than we have time possibly to cover today. There are literally hundreds of cognitive biases. And there are far fewer solutions than we might like. Cristina and I are not going to be able to give you today any magic formulas, no cookbook solutions for dealing with cognitive biases. What we are going to do, however, is help you recognize a cognitive bias when you see it, at least some of the more common ones. And maybe if you use them skillfully, not only improve your own decision making, but influence the decision makers on the other side of the table. Going backwards here for some reason, okay. All right. Cristina and I heartily recommend 3 books to you. If, as a result of our webinar today, you become more interested in cognitive biases, or maybe you're already interested in cognitive biases, these books you will enjoy. They're not dull. They're not academic necessarily. They are fun reads. And they provide a lot of useful information for lawyers, negotiators, mediators, and decision makers in general. All are filled, I mean, absolutely chock full of real life scenarios, studies that have been done in the way we think, and examples of cognitive biases at work. Heuristics. Now, this is a term you may or may not be familiar with. Heuristics are really an approach to problem solving that employs a practical method that's not necessarily guaranteed to be optimal, but nevertheless sufficient for an immediate short-term approximation of a decision. In short, they are mental shortcuts. As humans, we rarely have time to carefully analyze every bit of information available to us. If we tried, I suspect we might be like one of the robots in the science fiction films. We might blow a fuse and fizzle out. Instead, we use shortcuts. Sometimes they're shortcuts that we've derived through trial and error, but they're shortcuts that we can apply quickly to make decisions quickly. Problem is, sometimes those decisions are very poor ones. And the study of cognitive biases is the study of heuristics gone astray. And Cristina is going to actually kick it off today with 2 fairly common cognitive biases that we encounter in negotiation.
Thank you, Howard. So the first one is the bias, the fairness bias. We as humans are biased in favor of what we perceive as fair. And And the magic word there, I think, is also perceive, because it's you're seeing through all of those filters. For those of you who wear glasses, it's like when you go to the ophthalmologist and they're just checking your lenses, going this one or that one, right? So imagine this scenario: you've been released from COVID quarantine, and you're out back in the wild here, and I walk up to you. You don't know me. And I start speaking to you and another complete stranger at this place where you are. And I have in my hand 20 $1 bills. And so I tell you, you and this stranger over here, and we're going to play a little game. So I'm going to give you these 20 $1 bills, and you have the freedom to choose how you're going to divide them between yourself and this complete and total stranger. Now, the trick, however, is that the stranger must accept the division for the two of you to get the money. If this total stranger says, I don't like the way you divided that, then neither of you will get anything and I will get the $20 bills back. And so if you are going by an assumption that people are economic humans and out there to maximize utility and under all circumstances, that the sort of this economic model of humanity, right, that you're going to get the most for everything and every opportunity, you could pretty much keep those $19 and maybe give the other person $1. But what would happen? Would the other person accept the $1, or would they feel that that was unfair, right? Would you perhaps divide things a little more equally, keeping in mind that that other person might think it's unfair? So you're more content perhaps to get something like 9 and 11, 10 and 10. Here, that's fair, right? Because in that scenario, the two of you are going to actually walk away with the money, because if you hold on to $19 and you give the other person $1, they're going to be like, no way, man. I'd rather get nothing than get that dollar. They would be better off if they took the dollar than if they had zero, but they would rather sink the whole thing than accept such a measly, unfair offer, right? And there's a series of experiments known as the monkey justice experiments that were done at the Yerkes Primate Observatory with Sarah Brosnan and Franz de Waal. There's some great videos of this online if you want to Google, where they do this experiment in transparent plexiglass circumstances. They have a little monkey, a capuchin monkey, trained to give the investigator a rock in exchange for a treat. And so in one monkey is getting cucumbers for a treat, and then he sees that his neighbor is getting grapes, which is like a much tastier, better, higher value treat for monkeys. And the monkeys who keep getting cucumber will stop playing. They will go pout in the corner. There's one of the videos where the monkey actually throws the cucumber back in the face of the experiment, and the rock back in the face is like, hey, give me a grape. That's not fair. I see what you're doing with the other guy next door. So we're really deeply built, to deal with perceptions. We're sensitive to being treated unfairly. Next slide, please. And so, as negotiators, we would caution you to stay away from the word fair in some ways. I guess fairness is important. I don't think you can lose track of it. But when you use it with a conscious mind, because is it fair according to your perception? Is it fair according to what you think the other side will perceive as fair? And are you filtering that correctly? So sometimes there's sort of these inevitable moments in mediation where somebody will say something like, well, I think that's a fair offer to make to the other side, don't you think? Or they should think that's fair. Why don't they think that's fair, right? And in those moments, as a mediator, because you're in both rooms, you can tell that there's sort of a blindness perhaps to what the other person's sense of fairness might be, that it might be different. It's not better or worse, it's just different because they're standing in a different place. So a better way to think of it is to reframe the word fair. Is this acceptable to both sides? Is this something you can live with? Is this a solution that can work for everyone, right? You're starting to draw that circle that is an inclusive one. Today, for a complicated case, today we're going to see if we can find a solution that addresses everyone's concerns, right? So that, however, especially addressing everyone's concern, might seem impractical, perhaps, if all you're dealing with is a pot of money, right? If you're in a game of what's oh, next slide, please. If you're in a game of what's known where you think you feel like you're dealing with a fixed pie, just a pot of money, right? There's an insurance policy, or there's a certain limited number of assets and things of that sort. And so the idea of being in a zero-sum game, for example, which is one where if I get $1, it is only because you lost $1, right? Those $20, there were only 20 bucks. For every dollar that you got, the other person would lose one, right? And it's a complete and total closed game, closed loop kind of thing. Now, we would caution you to treat that concept of the fixed pie as a bias, right? A perception bias as well. And so the perception that every dollar or unit is of equal value might be correct. Doesn't always mean that it's not correct, but it might not be correct. There's always something else that you can, almost always something else that you can add to the situation. So imagine this scenario here where I have 5 oranges and you have 5 apples. Now, if we're going to be like straight fair, right? Maybe we're just going to divide them straight down the middle, and we're going to have 2 of each, 2 oranges, 2 apples each. Cut that third one in half, and we'll each get 2.5 oranges and 2.5 apples. But that assumes that apples and oranges are equal in value, equally interesting to me, and equally interesting to you. Maybe I like apples more than oranges, and I have a bunch of oranges. Maybe you like oranges more than apples, and you have a bunch of apples, right? And so if you start unpacking those perceptions, how do you end up with 2.5 pieces of fruit that you don't really want? You know, appealing to concepts of fairness potentially, where if you do a little more searching, you might find that there's something else that you can do there to get a better result for yourself than something that might be perceived to be the proper one. And you're able to start negotiating other factors. Now, how does this play out in mediation? What other value is there than just the dollar value placed on the dollar or the negotiation unit? Maybe somebody needs the money more urgently than the other side because they need the money now, money today versus money tomorrow. Somebody else has the ability to generate more money and the other person has less ability to generate money. But is there anything else that can be done? Work in kind, finish the work, right? In order to correct an issue. If you're in family law or probate world, sometimes people will get appraisers who will come up with different numbers for the same property, right? It's an opinion, right? But people treat it as factual. There's an ad for Dan Newland Law that played at one point, and it has a gentleman who is talking about having been offered $500 and then he finally settling for $990 million. And so, at the end of the ad, the gentleman is sitting inside this really nice pickup truck. Chances are that the ability to buy a really nice pickup truck was part of what this gentleman wanted out of those negotiations, for example. Are there outcomes and things that are more important than dollars and units? Confidentiality, releases, all of the other kinds of pieces that could be attached to a negotiation. And sometimes is the case really about dollars and units? Is the other side holding on to a principled negotiation position because they feel insulted or they feel that their honor is somehow besmirched, you know, that they need to save face in some way, shape, or form, that they need an apology, that they need some kind of an acknowledgement of some wrongdoing. And so all of those pieces are part of the reality that if you look at just the fixed pie dollar amount, you could lose track of these other things that could really get things done and help without necessarily even costing money in some instances. They can get things resolved and get a negotiation to be more satisfying for everybody involved. So back to you, Howard.
We're going to talk about what I think may be the most common cognitive bias, at least in negotiations. And this is the anchoring bias. I doubt you ever enter into a negotiation where the anchoring bias is not at work. And it's on the principle that we allow an initial reference point to distort our decisions. We start from that point merely because it's there and then adjust, and we often adjust insufficiently. Best example I can think of is you're buying a car and it's the manufacturer's suggested retail price, that sticker you see on the window. Well, first off, the M stands for manufacturer, so it's not what the dealer recommends. Suggested is suggested, it's not carved in stone, and retail is retail and not wholesale. But why do they put that sticker on the car? Well, they put that sticker on the car because it forms an anchor. It is designed to make you think that the car is worth that much money. They know you're probably, if you're an astute buyer at all, you're going to try to negotiate off of it. But they want to start at that anchor. Just a few examples and experiments have been done to show how powerful this anchoring bias is. One, the mock jury verdict study by Reed Hasty. And I've been involved as an attorney over the years in several large mock jury experiments myself, and I can tell you that Reed Hasty is right on. In the study, in one group, suggested range with the plaintiff's attorney was $15 million to $50 million. The verdict in those cases were $15 million. In another group, suggested range was $50 million to $150 million, and the verdict was $50 million, all on the same facts, same attorneys making the presentation. I had one where I thought my client, who was the risk manager for a large medical malpractice insurance company, I thought he was going to faint when the verdict came back at something like 130 million or something from one of the groups. But the big difference was what the range was suggested by the attorneys. Another interesting experiment is the Tversky-Kahneman experiment. In this study, the participants were shown a spinning wheel with numbers on it. And each participant would spin the wheel. And those that spun the wheel and it landed on a low number were asked, what percentage of African nations do you think are in the United Nations? Those that spun the low number guessed, excuse me, less than 25%. Actually, the slide's wrong there. And those that spun a high number guessed at more than 65%. And keep in mind, the number on the wheel had absolutely nothing to do with the question. It is merely the power of the number as an anchor. And anchoring is a very common tactic in negotiation. The plaintiff usually throws out a very high number, sometimes with a careful thought, sometimes not. If you're the defense attorney in those cases, defense negotiator, one of the first things that would be helpful for you to know is, does the plaintiff's attorney always throw out a number that's twice what he expects to get for his client at the end of the day, 3 times or 4 times? If you know that, you can find out. Attorneys get reputations around town by asking around. You get a pretty good idea of what their real anchor is at the end of the day. The poor defendant, of course, can only start at 0. But usually what happens, plaintiff throws out the large number, defendant throws out not 0, but a nominal sum, maybe $5,000. And at this point in time, setting the anchor may be the most critical decision either the plaintiff or the defendant makes in a mediation or a negotiation. And tell you something that I'm a firm believer in. The party with the most knowledge is always the most effective in setting the initial anchor. Always ask yourself when you're setting an anchor, what message do I want my anchor to send? And does the information available in the case support that number? You also need to ask yourself the other question. Why has the other person chosen their anchor? And does the information in the case support that anchor? Then from that point, most of the negotiation is consumed in convincing the other party why the information available in the case doesn't justify their anchor. And if you think about it, that's pretty much the skeleton of most negotiations. If you have widely disparate anchors, plaintiff is in the stratosphere and the defendant's the basement, that often leads to stalled negotiations or baby stepping. In baby stepping, of course, you can spend 2 days moving a $2,000 increment in a multi-million-dollar case. And my purpose today is not to discuss brackets, but I will tell you that one reason brackets are so effective is that they begin acclimating all the parties to new, different, more realistic anchors. You will see in the bracketing process, as first one bracket's proposed and then another and then another and then another, that gradually the parties tend to drift away from the initial unrealistic anchors. And that's one reason that anchoring is so effective. One of my favorite cartoons, I'll give you a minute to read it. You might try to envision how this negotiation plays out. And I may mention this cartoon again when it comes back to commitment and escalation of commitment. But this is an absolutely great example of someone throwing out an anchor. Now, as negotiation progresses, a remarkable thing happens. Theoretically, the first party to throw out an anchor gains the advantage. And usually this is the plaintiff. And sometimes I ask the defendant, do you really want to make the defendant throw out the first number? Because there may be some advantage to the defendant throwing out the first number, simply because it becomes the first anchor. But I know traditional defense wisdom is, no, we want to hear what the plaintiff's number is before we throw out a number. And I understand the wisdom in both of the positions. But over time, an interesting thing happens. Each party becomes increasingly and unduly influenced by their own anchor. It's another one of the ways that this cognitive bias works, and the result is, absent something like brackets, what stalls negotiations. As negotiators, we need to help ourselves and other parties change the game. And the best way I know this is the more information we have, the less effect anchors will have on us. And the more information we can give the other party as to why their anchor is wrong, the less effect the bias is going to have on them. For instance, the car dealer is a great example. No one should ever go to buy a car without knowing what the dealer paid for the car, and that's available in online searches. What the acceptable profit is on that, the general market for cars, and always keep in mind that the manufacturer's suggested retail price is not what the dealer paid for the car. In fact, it's not even going to reflect the dealer's profit. I spent years representing the automobile industry. There are all sorts of incentive bonuses paid to dealers, all sorts of, I use the term kickback, not in the derogatory sense, but all sort of back payments. So it's really hard to know how much money a dealer is going to have in the car at the end of the day. The point is, the more information you know, the less effect an anchor is going to have on you. And the more you can focus the other parties on that, then the more helpful that will be. This takes us to another damaging cognitive bias, and that is the overconfidence bias.
Right. Thank you, Howard. Anchors and anchoring is so important. That is one of the best ones to keep in mind. Overconfidence, I guess this part of the presentation is really about two of them that interact, right? Overconfidence bias and the illusion of control, the illusion that we have that we are masters of our destiny, right? That there is a destiny at all and it isn't random. There are differing streams of thought on that one, right? So overconfidence bias has to do with our tendency to exaggerate our abilities relative to others. For those who may have listened at some point in time to the now defunct NPR show the Prairie Home Companion, you'll recognize the term of Lake Wobegon. Lake Wobegon is this imaginary town where all the women are strong, all the men are good looking, and all of the children are above average, right? That seems absurd because we're sort of talking about in relative terms. When you're talking about your clients, though, you know, all of the cases are strong, all of the clients are good looking, and all of the jurors will be above average in order to get you the result that you're looking for. I actually have a magic 8-ball on my desk, which I will occasionally bust out to kind of remind people, you know, physically and visually break through the illusion of control that is brought on by this overconfidence bias, and a reminder that certainty is really only possible by agreement. You can't always be sure what's going to happen in front of a judge or a jury. But when you've spent the time in the bubble with your clients, working on your case, researching everything, getting everything lined up so it's the best and the strongest case you can possibly present, you spend so much time in that world that it can skew the evaluation in the direction that serves your side, right? It'll drive your anchor, it'll get you invested in your anchor, and it might even get you stuck in a place where you might have trouble moving from it there. One of the tidbits to keep in mind, though, for example, in New Jersey, when they first started the state lottery, people didn't play it as much until they allowed players to play their own numbers. And because now you are playing your grandma's birthday, your dog's anniversary, you know, the day the day you won a league championship kind of thing, and those are all your children's. Your children's ages, now that is surely going to be the winning ticket, right? Even though it doesn't do anything to change the odds of 1 in a gazillion that you're going to actually win that lottery ticket. The other sign of illusion of control there is that gamblers, as it goes around the table, they will bet on other people's rolls of dice, but when it comes for them to throw the dice, for a gambler to throw the dice, people who are gambling will often bet more on the roll of the dice that they're rolling, right? Big money, here's my turn, let's try it, right? So when you have people who are so certain that they are absolutely going to get that permanent alimony, or that the jury will surely find fault in this employer, or that if they could only present their story to jurors, that they will be found to be in the right. And both clients and lawyers fall victim to this, and it pushes people towards rolling the dice, as it were, and not properly weighing the risk of what that involves, because it's skewed upwards and more favorably towards their own position. Next slide, please. So maybe it's devil's advocacy time, right? When you're confronting as a mediator in particular, whoever your neutral is confronting a situation where they're in both rooms, hearing both sides, each one of them super excited about their own position. The expression devil's advocate comes from a practice that took place in the Catholic Church for a while, that when they were trying to decide if they were going to make somebody a saint and canonize them, that they would appoint a learned person from the church to do all of the research against the case that the church was making to canonize this person. And that person was the devil's advocate. They were saying why this person shouldn't be a saint, and maybe trying to find holes in the arguments and the evidence as to why that might be so. It can require some delicate handling, right? Here's this great person you want to make a saint. Here's this great case that you're sure is going to win. And so how do you do this in a way, from a neutral's perspective, to make sure people still think you're being neutral, right? And to do it effectively. It's one is the feeling side of it, and the other one is the effectiveness side of things, because ideally, a good devil's advocate will help you see that other perspective, make you walk in the other person's shoes for a second. And one way that a devil's advocate can do that effectively, in some instances, there are many, but one of the ways that a devil's advocate can do that is to put it in perspective of the bigger picture, right? We're talking forest and trees here in some ways. And the term I would like you to sort of focus in on is this idea of the base rate. The base rate fallacy is when you ignore the base rate. The base rate is the denominator over your particular under your particular situation, if it was a fraction, if you will. So if I watched on TV that somebody got eaten by a shark, and I'm now very afraid of sharks, and I'm not going to go to the beach, and I'm not going to take my family to the beach. Sharks are very scary now. What are the odds of my getting eaten by a shark at the beach, right? However, I'm going to get out the next day and I'm going to get in my car and drive to work or drive my kid to school. And I'm not even going to think about that, right? But if you were to look at the odds of getting in a car accident versus getting eaten by a shark, I should probably be more scared of driving, right? If you were looking in terms of the proportions and possibilities. So consider the possibility of the base rate in each situation as to how likely it is to be able to get policy loans, or the result, the long shot result that your client is willing to consider when they're weighing it against the certainty of an offer that might be a valid one in front of them, right? And so back to Howard on the sunk cost trap.
All right, we're going to talk a bit about the sunk cost trap. There are probably few cognitive biases that have been written about more than the sunk cost trap. There are so many examples of it, but in a nutshell, people tend to escalate their commitment to a course of action when they've already made substantial investments of time, money, or resources. You've heard the saying, throw good money after bad. One delightful psychological conundrum that's sometimes thrown about is delightful to consider. You go to Publix and Publix is having a big sale that day, so you buy one of their pre-prepared dinners for $5 and normally $10. They're half off today, blue light special. So you buy the $5 dinner and you take it home and you realize this looks good. You're going to invite a friend over. So you invite your friend over, and then as soon as they've accepted, you realize, well, gosh, I need another dinner. So you go back to Publix. Only problem is the sale is off. So now you have to pay $10 for this second dinner. So you take it home. You've barely gotten home when the friend calls and says an emergency's come up and they can't come. So now the question is, the dinners are highly perishable. They can't be frozen. So which dinner do you eat? The $5 dinner or the $10 dinner? Well, studies have suggested that you'll eat the $10 dinner simply because you have more invested in it. So that's one of the delightful. One of the more serious ones is the Vietnam War. Of course, volumes have been written about how we got into the Vietnam War after we had devoted so much in the way of men's lives and equipment that the prevailing attitude was, well, we've got to keep going, or else all the men who have died before will have died in vain. From someone who lived through the Vietnam War, I can tell you that that was the prevailing. The sunk cost trap was a very big trap during that proceeding. An experiment that's interesting is the dollar auction game theory that was done at Rand and Princeton. You have two participants in the study, and they're asked to bid on a $5 bill. I'm holding up a $5 bill, and I'm going to give that $5 bill to the highest bidder, and they have to bid in 25-cent increments. Well, the bidding goes on, but what do you think happened? Well, it happened that the price always exceeded $5, and the winning bid often was significantly above $5, let's say $6. So the highest bidder was paying $6 for a $5 bill. Why? Well, because the second highest bidder had to pay the amount of his or her bid and got nothing. So for the second highest bidder, there was a real incentive to keep bidding, even if it meant bidding more than $5. Otherwise, they were going to lose what they had in it. So that's a nice experimental. Another real life, I don't know how many of you have read Into Thin Air, which is about the ascent of Mount Everest. But several men died on one climb, and they died because, in retrospect, they had gotten almost to the peak when they saw that the weather was turning bad. They decided, we've come so far, we've invested so much time and so much effort that maybe we can, if we just push on, we can reach the top. Well, it cost them their lives. Another magnificent example of the sunk cost trap. And you see it in mediations all the time. In fact, I'm going to say something later about the escalation of commitment. You almost always see the sunk cost trap and the escalation of commitment go to get hand in hand. You've sunk so much money that not only do you keep going, but you begin to escalate your commitment. There is one positive side to the sunk cost trap, believe it or not, and that is it's also one of the big reasons that mediations work. As a lawyer, when mediations first began in the 1980s, I, of course, was attending mediations as a lawyer. It was not at all unusual for a mediation to go 16, 17, 18 hours. And cases often settle merely because at the end of those 16 to 18 hours, people had so much time and effort invested that they hated to walk away. Well, that sunk cost bias works even today, now that we're no longer doing the marathon mediations. So they do have a positive effect also. And anyone who's ever gambled, any poker player, any one who gambles in a casino has probably experienced a losing session. And the temptation is almost overpowering to keep playing to try to recoup their losses. And any of those people should immediately recognize the sunk cost trap. As negotiators, probably the best way we can avoid the sunk cost trap or its consequences is to try to focus everyone on gains and not losses. You've got to start people thinking about the future and not the past. In a failing business, for instance, sometimes in a business dispute, new opportunities may be available. I have mediated more than one case where the settlement involved a renewed agreement between the parties to continue doing business together, both with seeing the opportunity that they could both make money at the end of the day. In a failing marriage, maybe focus on the benefits to the parties and maybe to the children for moving forward. And another principle at work here is people are really better at making relative choices than absolute choices. People like to have choices. One thing that you might try when you're negotiating is tell the other party, here's what we can accomplish if we make this choice. Or why don't we try this? Another thing that's often effective is don't put out one proposal on the table, put out alternative proposals. People are more inclined to choose between alternative proposals than they are single proposals. So that's another way of overcoming the sunk cost trap. And we'll let Cristina continue with the next delightful bias.
Confirmation bias. So our tendency as people, our brains are trying to move things from the pile of things that we don't understand and haven't made a decision about into the pile of things that we completely understand. This is what it is, and we've made a decision about it. And we don't like to relitigate the case as it is. It's very hard to kind of get people to go back and review and reflect and reevaluate on a decision that's already made. We don't like to admit we made a mistake the first time. We don't like things that contradict our existing views. And it's even to the point where we will resist information that clashes with those particular views in particular. And that's known as the confirmation bias, the idea that we as humans will look around at the world and cherry pick the information that supports our position. As lawyers, we're trained to kind of do that, right? We're instructed to look at the stuff that's bad, right? You have a duty to point out the flaws in your case, to provide the bad law. Yes, you're doing all of that stuff. But over here is all the stuff that supports my case, right? So that you spend a lot more time on the stuff that strengthens it potentially, at least when you're going to present that. Now, we talked about overconfidence before. Confidence is very useful, right? Confidence is, well, in the fake it till you make it or appear confident and wow them in such a way that confidence of presentation is very powerful. But if it's used intentionally, I think the caution is to beware of self-deceptive confidence, where you're sort of stuck in a confirmation bias trap and you're like a horse with blinders, right? You're only able to see a certain part of it as in a certain kind of way and not perceive that it might be a risk. The 2003 Columbia shuttle disaster is an example, again, where people's lives were lost. The issue that caused that crash was known to NASA. They just didn't think of it as a safety issue. And so they even talked about it on the pre-flight check before the shuttle took off. And it was pieces of foam that had come and hit the leading edge of the wing. And upon reentry, that wing burned and caused the whole shuttle to burn. And if they had viewed that as a safety issue, that would have been something that caused the launch to abort, would have been fixed, would have been addressed potentially. But it wasn't. They just sort of saw it as part of the universe of what was acceptable, and it cost the astronauts their lives. And so another thing that people are experiencing in their lives on a daily basis is that confirmation bias is kind of baked into the algorithms of all of the social media and searches that you're using online. And so if Google or if Amazon gets wind that you are suddenly interested in buying a kayak, you know, you're going to see ads for kayak in all of your thread, and you might not even have gotten to the search. It might be your smart speaker that's kind of heard you mention kayak. They're like, let's see if we can sell this person a kayak. If Google finds out that you're interested in a particular, or Facebook rather finds out that you're interested in a particular topic, it will feed you random seeming posts that are actually carefully calibrated to line up with what you are interested in, even if you don't go looking for them in the first place. And so all of that flow of information, without you even seeking it out consciously, it's just coming at you and serving to confirm interests that you might already have or beliefs that you might already hold. And it's contributed to polarization on a national level for people ending up in biases. And so the Salem witch trial is another people losing their lives kind of scenario of confirmation bias, right? This person is saying that it makes no difference what I say because you've decided I'm already guilty. That merely serves to confirm that this person understands what you're saying and can read minds and clearly must be a witch. So confirmation bias is a powerful trap to fall into, not just in negotiation, just in life in general. And so one of the ways that you see those kinds of preconceived beliefs are in statements like, this is just like the case I won last month. But is it? What about these different facts? They're never going to get that into evidence. Well, what if they do? Let's brainstorm how they might. And if they did, what effect would it have, right? So instead of stopping your logic at the place of they're never going to get that into evidence, play out the scenario where they might and then what if, right? Juries in Orange are very conservative. What if you happen to get one that's seated that isn't? The judge is sure to grant my client a summary judgment. I haven't seen a judge in Seminole County grant child custody to the father in years. So these are these preconceived beliefs that people might have about their case, about the likelihood, right? You know, if you're talking in sort of getting to yes terms, this is a person's perceived most likely alternative, right? People really strongly think that this is what's going to turn out, the most likely alternative if the case ends up in court. But it can blind you to your worst case scenario, to your best case scenario, and to other likely cases that might be out there in the range. And so being stuck on that will prevent a clear-eyed evaluation of offers that you might have in front of you. Not prevent, but it could interfere. So.
All right, groupthink. I don't know how many of our audience today were alive in the 1960s. I was. I remember the Bay of Pigs invasion. And interesting thing, in fact, one of the books that Cristina and I recommended to you, it's The Art of Critical Decision Making by Michael Roberto, has a very lengthy discussion of this. And just if you have an interest in history, I would recommend that great course to you. John Kennedy had been in office for 77 days when, of course, they found out that Castro had taken over power in Cuba. A bunch of ex-Cuban patriots were going to storm Cuba and try to wrest power away from Castro. And they proposed that the United States provide air cover and logistic support for these expatriates. Kennedy discussed the invasion with a large group of his advisors. And they decided, of course, to go forward with support the Bay of Pigs invasion. The last-minute political pressure caused them to withdraw the support. The result was that a lot of expatriates were slaughtered on the beach at the Bay of Pigs. Later, Arthur Schlesinger and Chester Bowles, who had been involved in the group discussions, expressed regret that they'd not spoken up in the group sessions because they had real reservations regarding the invasion. This is probably as good an illustration of groupthink as that I know of. It's when members of a cohesive group let their desire for a unanimous decision override a realistic appraisal of alternative courses of action. You've heard the saying, we get along to go along. They tend to converge on one idea and not engage in a candid conversation about the others. In negotiations and mediations, you frequently encounter this wherever you have groups making a decision on for one party or the other, or sometimes both. It's more common than you think. For instance, I do homeowners association mediations, and you haven't seen a group in action until you watch a group of homeowners the board of a homeowners association trying to decide whether to resolve a case. You have governmental bodies; they'll often have, the governmental attorney, the litigation attorney, the risk manager, the person from planning and development, the city manager, several people there, insurance claims, sometimes family mediations when you have a group on either side. It's less rare in those. Medical malpractice cases. You see this often. Anytime you have a group of people representing a corporation or a legal entity, groupthink comes into play. There's often one or two dominant members who run the show, and as mediators, we see this certainly in caucuses. And you always have people sitting on the periphery wanting to avoid feuds within the group. How do you harness the power of all the members to explore? Well, for negotiators, that's hard because you aren't in the other caucus. But this is a place where you can enlist the aid of a mediator. You ought to ask the mediator. Most mediators are not going to tell you who's making the decisions in the other room for ethical reasons. But you might say, look, make sure that Bill Smith in the other room is participating, because we know he's got a different opinion from the rest. So to that extent, the mediator can provide some assistance, helping make sure that everyone in the room is participating. And it's a simple way to do it. Well, we haven't heard yet from Bill Smith. And of course, the risk you run if you're a mediator is, well, we didn't ask you to ask Bill Smith, from the alpha male in the group. But it's a real problem that you frequently encounter. This brings us to a few caveats and a few wrap-up examples.
So we haven't, like Howard said, we haven't touched on everything by a long shot. This is like a 1-hour version of a really extended psychology and negotiation course, essentially. It's our goal today is just to point out to you some of the main ones and help you think about ways that you can use them when you're negotiating. So both to prevent yourself from falling into those traps, but also to use them to your advantage if you see that that's something going on the other side. And the 3 books that we recommended are great reads. So the Goldman, the Cialdini, and the Roberto books, there's a lot of great examples in there that just illustrate these layers of thinking, that how we get there. In some ways our brain, our nervous system is like one of those cones with the different layers, right? You have sort of your lizard brain, your monkey brain wrapped around it, and that more developed human brain on the outside. But you're not always using that outer layer, as it were. Some of those reactions are so baked in deep down inside that you really have to push back with conscious thinking to keep yourself from getting stuck with that type of thought.
Cristina, I would also add at this point, there are some other books that if you're really interested in becoming a good negotiator, I would highly recommend to you. One is Bob Wolf's book called Friendly Persuasion. It may well be out of print, but you can still obtain it if you go to Amazon. One of the best books on negotiation I have ever read. Bob Wolf was a very well-known negotiator who negotiated sports contracts for people like Larry Bird and Howard Cosell and a lot of very famous athletes. He has like 94 pointers in the back that's worth, copying and putting on your bulletin board. Another couple books are You Can Negotiate Anything by Herb Cohen. And another of his, with his marvelous chutzpah, tongue-in-cheek presentation, is Negotiate This by Caring, but not that much. So those are three really good books that I might add to the list. All right, Cristina, I think you were about to go into a few sort of.
I know. I don't know if we're out of time. It's at 1 o'clock, so we have a couple of extra slides here with respect to some of the.
You have until 1:10 or so.
Yeah,
all right.
We got a 5-minute webinar. You're good.
So,
all right.
Let's get a couple of the extra points then.
All right, and I didn't know if we have any questions. Hopefully, you guys are putting them in the chat, and Kathy will go over them there at the end.
Yeah. Well, let's ask Kathy. Kathy, do you have any questions that have cropped up that maybe we need to address?
I'm taking a look right now. I see one. One moment, please. Oh, yes, here's some. What was the third book recommended? The screen passed too quickly to copy.
Yeah, the third book I just recommended.
I think the one that was on the screen is the Cialdini one.
The Cialdini, it's
Persuasion.
Yeah, it is Influence is the title. And it's by Robert Cialdini. In fact, it just blew me away. It's how you influence other people and how they influence you. Marvelous book. I highly recommend it.
We actually have a number of questions about the books, and we are going to share the slides too in our follow-up email, which comes in 2 days. So you'll be able to get that information. We'll share it as a PDF so that you can.
Well, let's do this. I think. See if I can. Oh, you've got can you go back to that slide, Kathy?
I can. One moment. Okay. Do you remember what number slide it was?
It was very early
on.
Yeah.
4 or 5. Yeah.
All right.
Probably about slide 7 on yours. Yes. The Science of Settlement, Ideas for Negotiators by Barry Goldman. Goldman is a mediator. This really sort of takes a nuts and bolts approach to cognitive biases. He was a speaker at the last dispute resolution conference. So it's a very, in fact, let's see. I think I've got it here. That's the book. Very interesting book. The Art of Critical Decision Making by Professor Michael Roberto is actually a great course. It's a college course really that you can purchase online, and you can get that through audible.com or through the Great Courses. This happens to be the course book that is at one time accompanied the course, but doesn't anymore unless you buy it separately. And then the last one, Influence, The Psychology of Persuasion by Robert Cialdini. What more can I say? It's just one of the most delightful reads of a long time. One, he talks about, for those of you who can remember the Hare Krishnas, who used to offer you little red flowers in the airport concourses. And once you accepted their free little red flowers, they tried to sell you a book. He talks about one that I'm sorry we didn't have time to talk about, commitment and consistency. In fact, I might mention that since we're there, is give you an example. In an experiment, the experimenters went into a neighborhood and they asked everybody, or at least half the people, if they would put a small sign in their yard that said, "Be a safe driver." And a lot of people did that. It was a small, not too obvious sign. And then they went back and they asked those same people in a couple of weeks to put like what amounted to a billboard in their yard that said, "Be a safe driver." Well, of the people who had accepted the small sign, 76% accepted the billboard. Of those who'd never been offered the small sign, 83% rejected the billboard. So this is an example of commitment and how people tend to stay consistent with that. It's why Amazon, when he asks you to put something that you're thinking about buying in the cart, even though you can take it out later, Amazon knows that once you've made the commitment of putting it in the cart, then you're apt to stay consistent with that commitment. And I could go on and on. There's a whole bunch of those examples.
You still had a couple of slides left if you want to go back there for those.
Well, I think this might be your slide.
Yes.
Cristina, go ahead.
You're just talking about your Amazon example. There's a documentary on Netflix called The Social Dilemma that talks about how social media uses all of these social psychology tendencies in our brain to get us to buy stuff and to spend time and attention on different sites and on different spaces. There's a lot. I love these biases, but I think my favorite one right now is the endowment effect, that we overvalue anything that we perceive as ours. I think you see that in mediation a lot of times. It's kind of like the toddler's rules of possession. If I like it, it's mine. If it's broken, it's yours. If you have it and I want it, it's mine. So anything, if I have this pen or this pen, it's like it's very sentimentally important, and somebody gave it to me and I would never part with it, not for any amount of money potentially that you would ever offer me, but if you have it, it's just a tiny pen, right? So why are you making such a big deal out of it? So the endowment effect as anything that's ours is more valuable. The affirmation bias, I think you see a lot of times. People on the whole, you want people to like you. You want that first impression to be a connected one. Not everybody needs that like. Some people actually have like a tweaked version of it where they want respect, or they want people to be afraid of them, or they want people to see them in a particular way, view them as intelligent or something like that. So whatever sense of value that the person needs from that, we behave in such a way that we want the other people to reflect that back to us, for them to be our mirrors on that. I want you to agree with me so much so, and then I'm gonna try to get you to change your behavior to be consistent with me, or potentially that I'm gonna change my behavior to be consistent with yours. So in that case, there is that tendency to kind of mirror each other in a way that is affirming to a person's identity. What else? I don't think even we wouldn't have the time to go into all of these, but since Howard was pointing out a couple that are on the next slide over, Kathy, if you want to put that one up as well.
Yeah, you can see that there are just we've just touched the iceberg today. There's so many of these. The left digit bias is fascinating. Self-serving bias is certainly certainty of position effect. You know, the position of two things affect your decision. You know, millions of dollars are spent by merchandisers. In fact, these sales reps will go into a grocery store and literally fight over who gets the most favorable position on the shelf for their product. The commitment and consistency bias, though, is really one that just comes through constantly. I do hope we've done enough today to get you into the subject, because I can tell you that it made me a much better negotiator and a much better mediator. We just don't think like we think we think. And we have to come to grips with that and deal with it as best we can. Any other questions?
There is one that mentions racial bias, and I think we did talk about that a little bit before we got underway here today.
Okay, that's important.
A little different tack. Yeah.
Yeah, we haven't talked about cultural biases today, but please, I think it's important to understand that cognitive biases and cultural biases sort of go hand in hand. The cognitive bias tends to make us more vulnerable to a cultural bias. And culture, of course, helps create the cognitive bias. It's sort of a never-ending loop. So we didn't talk about cultural biases today, but if you spend some serious time thinking about it, you'll see how cognitive biases play in to the development of cultural biases and racial biases.
That's something that I've done a fair amount of training on my end of things as well. I think my best example to people in the context of this talk that you just heard, because that alone deserves its own time, is if you think of it as the example of the horse with the blinkers, right? People can only see the world from their own perspective, and sometimes they don't see what they can't see. They might not be able to see past a set of experiences that are only their own into somebody else's that they have either don't understand well or don't even know are there. And that creates a lot of territory for misunderstanding. One of the biases that we didn't go into much is the fact that we perceive ourselves as normal. We are the mean in the world. And so everything is measured in relation to that. And people are just bad at evaluating something on its own and always tend to do it in comparison to one another. And so in some situations, it can get challenging when you're thinking what you think is normal is somebody else is not normal, or acceptable somebody else is not acceptable. So it calls a lot on conflict resolution skills in terms of trying to get people to a place where they're at least on common ground to be able to move forward on questions of racial, ethnic, gender, class, sexuality, all of the different biases that people are dealing with from as far as the diversity perspective and how it interacts with bias.
We're starting to get the questions piling up about the CLE number. So for everyone who's been wondering, if you're a Florida attorney, please jot down the Florida Bar Course number so that you can post your 1.5 hours of general CLE credit for this 75 minutes of instruction. The number is 210-457-1N as in Nancy. Again, that's 210-457-1N as in Nancy. Please make a note of our contact information in case you want to get in touch with us later, right here on this slide. Thanks for joining us today. Our next CLE webinar is scheduled for August 5th, and it will feature members of our Center for National Class and Mass Actions. Thanks, Howard and Cristina.
Thanks,
Thank
Kathy.
you, folks. We enjoyed it.
Have a great afternoon, everyone.
Same. Be well.